past might have viewed anti-arbitration injunctions with a certain degree of favor, but now have become extremely circumspect about granting this remedy, and of late have even doubted the existence of their jurisdiction to grant this remedy at all. And this, in fact, brings me to the first issue, which I'd like to put before our esteemed speakers. This issue concerns the jurisdiction to grant these injunctions. In a number of decisions, most recent of which is the decision of Beena Modi versus Lalit Modi, Justice Enlaw of the Delhi High Court has followed the Supreme Court decision in Kavanagh cementation. It's a 2001 decision of the Supreme Court, and held that civil courts lack jurisdiction completely to hear suits for grant of anti-arbitration injunctions in view of Section 5 and Section 16 of the Arbitration and Conciliation Act. Now, this viewpoint essentially espouses the negative competence principle, which gives priority to an arbitral tribunal to adjudicate the validity of an arbitration agreement over a court. So the first question that I would put to the speakers is if they would kindly weigh in on whether they believe this viewpoint is correct and consistent with the other body of law that we have on this, or do they feel that it is inconsistent and requires reconsideration? So, Mr. Jain, would you like to begin by giving us your views?
Yes. As we have seen from the conspectus of cases which are available, both in Supreme Court and Delhi High Court, there are two schools of thought which are prevalent. First school says competence principle negates all other jurisdiction. Second school of thought is unless ousted, civil court prevails. Now, the entire body of case laws which you have discussed and mentioned and which we are about to discuss in the course of this webinar revolves around one of the two principles or one of the two schools of thoughts, whichever way a particular bench would like to take it. Now, the difficulty with Beena Modi case is that it almost entirely relies on Supreme Court's case judgment in Quiner cementation, which came in 2001 and which got published in 2012. Because it remained in wilderness for 11 years, that could be the reason why this judgment was not noticed by any of the benches subsequently, especially by SBP versus Patel Engineering. SVP versus Patel Engineering is a 7-judge bench which does not believe that Section 16 is a complete code in itself in every situation, especially where the court has had occasion to deal with a matter in Section 11 or in Section 8. The Supreme Court and SVP made it very categorical that Section 16 would not be a complete code in itself. So in a sense, if we see, the judgment in Quiner is equivalent to the minority view taken by Justice Thakkar in the case of SBP. So therefore, we need to understand this perspective from the approach which we take. If we see the Arbitration Act, almost more than 20% of the Arbitration Act, especially I'm talking about Part 1, shows us the door to the courts. Section 8, 9, 11, 16, 27, 34, 36, 37, and even 13. These are 8 or 9 provisions which lead us to assistance of court. Now, if we have a Part 1 of our Arbitration Act, which has almost 20% of the provisions which lead us to the door of the court, and ultimately a matter has to be decided by the court in one way or other, then why there is so much of reluctance if the question which confront a court in an anti-arbitration injunction are dealt with by a civil court? Because in our case, in our act, competence principle in its negative form cannot be constitute as the correct proposition of law in my view. If we see, there are largely 4 grounds on which a challenge is mounted for an anti-arbitration injunction: non-arbitrability of the dispute, forum non-convenience, abuse of process of law, and overlapping of the issues. And there are 2 tests which Supreme Court has applied on the other side of the aspect, which is null and void, inoperative, or incapable of being performed. That is, the agreement must be such which is null and void, or inoperable or incapable of being performed. The second test is the proceedings are vexatious, oppressive, or are the continuation thereof would be abuse of process. If we see this perspective, then it clearly emerges that if ultimately a particular proposition of law is to be tested by a court only, and in this scenario where the question of arbitrability is only one of the possible grounds which will be taken in an anti-arbitration injunction, the 3 other grounds which are taken, which is abuse of process of court or process of law, overlapping of issues, or forum non-convenience, do not have anything to do with part 1. So therefore, these are the issues which need to be gone into by a civil court only. And ultimately, as the act is structured, eventually they will be gone into by a civil court only. Therefore, to say that merely on the basis of a 1-page judgment in corner cementation, where a very simplistic approach is adopted, that all right, because section 16 and read with section 5, if they are taken into consideration, then the arbitrator has a jurisdiction to go into his own jurisdiction. So they very simplistically, without discussing law, have applied a principle which leaves much to be desired. So therefore, in the subsequent judgments also, when Supreme Court had occasion to deal with, for instance, if we take the latest judgment of Swami, which is 2016. Swami also deals with Section 8. It does not say that merely because a party takes a ground of Section 8, so automatically the matter will be referred to arbitration. It does accept a proposition, which is a basic proposition, that yes, if Section 8 is filed, a civil court will have to apply its mind as to whether a matter has to go to the arbitration or not. If this is the scene, then why should there be a reluctance to entertain anti-injunction arbitration matters in arbitration regime by the civil courts? That's my point.
Yeah, thank you, sir. Thank you, Mr. Rao. Your view on this?
Thanks, Ashutosh. At the outset, I want to thank you, and more importantly, NLSIR, for having me, on this panel, especially with Mr. Jain, who's somebody who's been very, very kind to me, and I really look up to. But on a more lighter note, I had the occasion of, speaking on the same subject a week ago. And for those from NLS, they are familiar with the old adage. In law school, you're only called upon to, speak on the same thing, or effectively write the same paper twice if you flunked the first one. So for me, this is my repeat, and I hope I do better than I did on the last one. But now coming back to, personally speaking, I believe that some amount of judicial intervention is necessary. And I subscribe to the view that it should be obviously extremely rare and limited. Having said that, I'm just, since Mr. Jain has put forth a view, I was just wondering if I could just try and, elaborate on the counterfactual and see whether there is an underlying logic that permeates the need to keep the regular civil court out, and while at the same time ensuring that there are enough checks and balances in the legal framework, particularly under the 96 Act, for redressal of any grievance that a party may have. And taking a cue from what Mr. Jain has pointed out, the fact that Part 1, and again speaking largely for domestic arbitrations, itself provides so many instances for judicial intervention, is indicative of legislative intent, particularly with reference to the language of Section 5, that there is an implied ouster of the civil court's regular jurisdiction. And which is why the language of Section 5, which says no court shall interfere except as provided in this part. Now, if it was very simple for the legislature to go ahead and just put in one extra line to say nothing would, and just to clarify, saying that nothing would prevent a court from exercising anti-suit injunction powers, because the approach, particularly in the UK, with regard to the English courts taking recourse to their inherent jurisdiction and preserving the right of the ordinary court to pass anti-arbitration injunctions, was already well established. So purely from a lawmaking standpoint and a historical lens, I feel that we would perhaps be doing disservice to the object of the legislation if we were to encourage civil intervention. But Mr. Jain is absolutely right. I think even in Ayaswamy, ultimately the court does recognize that a civil court may be able to exercise jurisdiction. I'm just wondering whether, in the absence of a specific and a final determination by the Honorable Supreme Court, this question is still open. And I would tend to err on the side of what Justice Enlaw says. I agree with Mr. Jain that Querner perhaps hasn't fleshed out the reasons as to why, its conclusion in that one solitary paragraph. It's virtually a short 6-para. And I would venture to think whether one could say it's a judgment if you go by the strict rules of how to carve out ratios, etc. But it is an observation by the Supreme Court. It is binding. But I think the underlying logic is exactly that. SBP dealt with a Section 11 in a very, very limited context, administrative, judicial. The observations, of course, are valid. But the whole principle is this: if the lawmaker wanted, in the backdrop of world events which were known to Parliament, that civil courts would entertain, then Section 5 really is rendered meaningless. That's part 1. Part 2 is the entire emphasis, particularly in the Arbitration and Conciliation Act, is largely on commercial arbitration. And again, that's something that one needs to keep in mind. There is an increasing trend to interpret commercial agreements in a commercial manner, as if a businessman would do it. There is no reason for a court, therefore, to step in and act as a parens patriae when two people who are businessmen have shaken hands, have shook hands on an arrangement which, in their respective views, provides a venue for resolution of a possible future dispute. And one would give them the benefit of doubt to the extent that they've thought through this whole process, whether it is domestic arbitration at the hands of a tribunal which they have either already appointed or have the ability to appoint by mutual consent. And now, of course, we have, with the amendment of Section 11, in 11A in particular, 6A, we have further protections brought in. And more importantly, the fact that they've thought through the commercial considerations of it. So which is why when one looks at oppressive and vexatious and those parameters, and I'm sure we'll discuss those in a little more detail, courts have said commercial considerations are irrelevant. So really speaking, unless it's a really, really egregious case, I would be very reluctant to think that a court ought to exercise jurisdiction. Having said that, the last point on this is that an individual does have the means of ultimately seeking redress. The only difference is it a straight, dart to the center where you say anti-arbitration injunctions, so therefore no further movement? Or is it that you go through the motions and ultimately come back at a stage of enforcement or otherwise, or in the seat in the supervisory court and get some relief? So I think the jury is still out there, but Mr. Jain is absolutely right. I mean, as things stand currently, it does appear that Indian courts do have the ability, and perhaps Justice Enlaw might be a lone warrior who's on the other side, and Querner, as we all know, kind of, perhaps rightly, and it's a Freudian slip, but probably was rightly, shoved into historical databases till SEC pulled it out, barring JT. I don't think anybody else saw it till 2012 or so. So that must be, at times they say, jo hota hai, achhe ke liye hota hai, and perhaps this was God's way of ensuring that what they believed was bad law did not happen. But yeah, that's the way I would see it for now.
Thank you, sir. Sir, before we move on, I just thought I would ask you to comment very briefly, because both of you referred to the decision in Ayaswamy. In Ayaswamy, the court said that Kavanagh cementation would apply and a suit would be barred if an arbitral tribunal is constituted at the instance of one of the parties and the other party takes up the matter in an anti-arbitration injunction, suit for anti-arbitration injunction. But the court said it would not apply if a suit was filed seeking the actual reliefs or seeking some declaratory reliefs unconnected to an anti-arbitration injunction and a Section 8 were filed. So the court draws this distinction, and it appears as if it's basically created the scenario where it's a race. So if one party gets to the court first, then it can raise all these issues before the court. But if it is beaten to the post and arbitration is commenced, then it must wait its turn. So do you feel this distinction is logical? Should it be something the court should reinforce? Or is it something that we should reconsider, this entire distinction, and that the position should be the same either ways? Maybe Mr. Jain, sir, if you could just weigh in on this.
In my respectful view, this proposition needs to be reconsidered by the Honorable Supreme Court. One of the reasons being that the judgment in I.S. Swamy does not mention about SBP at all. Mr. Rao is right that SBP is primarily on Section 11. But then we are actually analyzing all these judgments in the context of different sections, which ultimately lead to the same proposition that when we speak about the principle of competence, ordinarily it is right. But when it is negatively applied to oust all other jurisdictions, and when the second principle, with the problem with I.S. Swamy is this, that the second proposition, which is like, unless ousted, civil courts would prevail, which is a proposition which has been articulated by several two-judge benches of Honorable Supreme Court, that is Chatterjee Petrochem, Gangabai, WSG. So there have been n number of judgments in Supreme Court which have said that by virtue of Section 9, the civil court jurisdiction is not ousted. And even if you see the dictum in Vodafone, though Vodafone was outside Arbitration Act, the basic proposition which has been laid is this, that the civil court would have a jurisdiction to go into the aspect, because as I said in the beginning, that the entire arbitration injunction is not limited only to the arbitrability of the dispute. There are several other dimensions which may creep in a matter which is brought in seeking injunction against an arbitration. And the most important being would be abuse of process of court. And so therefore, this kind of a dispute which engages the adjudication process to an extent where the arbitrator's discretion may not be sufficient, and ultimately when these kind of matters have to be brought to the civil courts only, then what could be the point of reluctance that they can be heard in the first place? So therefore, my only problem with I.S. Swamy is that it has not discussed the second school of thought, that is, unless specifically ousted, civil courts would prevail.
Thank you, sir. Mr. Rao, any view on this distinction?
Yeah, sorry. Again, I guess I have the same problem with I.S. Swamy as I have with a lot of elaborate on various other aspects. And somewhere along the way, the question therefore is, really speaking, was the court called upon to answer that question? The short question in I.S. Swamy was fraud arbitrable? That's really the sum and substance of the issue. The Supreme Court goes into this elaborate by alley and effectively seems to suggest that if an arbitration process is already in place, then really speaking, the tribunal has precedence and competence would prevail. The flip side is, of course, if a party has gone to court and a Section 8 has been filed, then of course it's the mandate of the court. But I think, again, missing the wood for the trees, if the principle is that the court is equipped either ways, then it doesn't matter, right? Whether it is pre or post, the court, if as long as the right boxes are ticked, the court should have jurisdiction. And that seems to be the flow from the various Supreme Court decisions, as Mr. Jain rightly points out, Chatterjee, etc. I think even the high courts, everybody barring the odd exception, and Justice Enlaw seems to be one of them, seem to suggest that the civil court's jurisdiction is preserved. And that seems also to be the worldview. I mean, it's understandable in the sense courts have some reluctance in letting go of their jurisdiction, and they find ways to give it in. My concern as a lawyer, particularly from a commercial arbitration standpoint, and is certainty, and that's something that I feel that is still lacking, and at two levels, right? When you advise a client on whether or not he or she needs to opt for an arbitration clause, and you've negotiated a complicated commercial structure and you've incorporated a foreign seated arbitration clause, or perhaps a domestic seated arbitration clause with a 3-member tribunal, and you clarify that all 3 members will be former judges of the Supreme Court, etc., etc. And then suddenly one of the parties runs to court and a civil court decides to intervene. Now that creates complications, particularly also because of the lack of clarity in terms of the yardsticks that are to be applied. Now, what is oppressive? What is vexatious? All of this really, are still nebulous to a large extent. And frankly, you take the same case to 3 different judges and chances are on the same set of facts, you'll get 3 different answers. That's why I feel that the reason I.S. Swamy makes that subtle distinction, and you can defend that from the purposes with reference to the statute, what should, in keeping in view the principle under Section 5, defer to competence. And that again is exercise of a court's powers within the framework of the Arbitration Act. And if a party has come to a court, then of course a court is obliged in the first instance. And this is where, sir, perhaps, this is something that I've always wondered. Could a court, merely because it is faced with a section, with a suit where on the face of it, the arbitration clause seems to suggest that there is a clear intent to arbitrate, notwithstanding the principle of waiver, could a court say, I will refuse to issue summons because of a Section 5? And the only answer, of course, appears to be in Section 8, because at the end of the day, a party is entitled to waive the right to arbitrate, notwithstanding the written agreement. So from that perspective, I don't see any real issue in terms of the way I.S. Swamy has approached it. I.S. Swamy seems to balance the role of a court from a Section 5 perspective and keeps open the window. And frankly, I would not read I.S. Swamy as an indicator, notwithstanding the fact that Mr. Subramanian's argument is in a sense upheld, applying strict ratio principles, that I.S. Swamy is really a judgment which goes to the root of saying that a civil court can and does have the ability to exercise jurisdiction. I would argue that I.S. Swamy is should be read limited to the question of arbitrability of fraud and in what circumstances. Everything else is obiter. I'm conscious that the Supreme Court has effectively said obiter is also binding, but that is why we need a definitive pronouncement from a larger bench, on this aspect, because you have to balance SBP, the various, observations made in SBP versus really speaking this need to redefine limited judicial intervention.
Right. Thank you, sir. Thank you. I'll move to the next issue, which also links to Beena Modi, because in Beena Modi, Justice Enlaw observed that another reason for not granting an anti-arbitration injunction or even entertaining a suit for an anti-arbitration injunction is because seeking relief under Section 16 of the Act would be equally efficacious. And therefore, Section 41H of the Specific Relief Act, which bars the grant of an injunction when efficacious relief can be certainly obtained by any other mode, would apply. So the question that really arises is this analysis correct? Is it fair to suggest that the relief you get under Section 16 is equally efficacious and can certainly be obtained? So maybe this time we could begin with Mr. Rao and then go to Mr. Jain, if that's all right. I thought. Yeah,
see, I see the point that Justice Enlaw makes, and more importantly, the question of efficacy again is something that is to some extent subjective. It's not an objective test, right? What is efficacious for 2 large corporations who have agreed, on a complicated commercial structure with an arbitration clause, conscious of the time, perhaps expedition in terms of time, but the expense. Arbitration is not cheap by any stretch of imagination. And the framework of the Act and the historical basis of judicial intervention, then it is efficacious. I mean, they thought it was efficacious when they were signing the contract. There is no reason for a court, therefore, to conclude that it is no longer efficacious. And again, that's why. So I think, I had the privilege of assisting Mr. O.P. Malhotra as a raw junior on his first edition of the Arbitration Act. And trust me, it was one of the most learning experiences to see somebody at that age pick up a new statute and dive into it, So I'd come in every morning and look at the notes he had dictated the night before, and I was supposed to proofread. And it all started because he heard a lecture on party autonomy. And according to him, that was the underlying, principle that essentially was the heart of the Arbitration and Conciliation Act. So if two parties have agreed, then it is deemed to be efficacious. It is deemed to be something that they wanted to do. And that's why Section 5. So I really believe that, therefore, again, like I said, I maintain that Querner is in the right vein, perhaps not correctly thrashed out, but there is no reason for a court to interfere. And that's why competence. Especially because, especially in the light of the lack of particularly guiding principles on what can we interfere and in what circumstances can you interfere. And that they will eventually take us back to the distinction in the language of Section 8 versus Section 45. And more importantly, with more recent amendments, all of which go to suggest that, the legislature is very, very clear. We want to carve out a separate jurisdiction. We want to take the civil court out of the reckoning. And where we want a court to interfere, it will be effectively in the nature of an application to the court in exercise of powers under the Act, rather than, a simpliciter suit. Except, of course, and that's the only place where we have the Sukanya line, where it is not possible. Now, even Sukanya, please remember, in a sense, Chloro has to some extent diluted the Sukanya principle. But again, there is obviously some basis for Chloro. And again, there is some amount of debate on does Chloro effectively rewrite agreements for parties where intention was very clear, especially with exclusive jurisdiction clauses. So I think I agree with Justice Endlaw. I think it is efficacious, and the lens is not really efficacious from an objective standpoint. It is efficacy from a party standpoint at the time they sign.
Thank you, sir. Mr. Jain, sir, your view on this point?
I would say that Justice Endlaw is one of the most brilliant judges we have in Delhi High Court. So it's not for nothing that he says something. So when he said that Section 16 is available, and that is a complete code in itself, and when he relied on Querner judgment, which is a 3-judge judgment of Supreme Court, he had valid reasons for doing so. But the problem is this, that the reliance was one-sided and certain other aspects were not examined. For instance, when we say equally efficacious remedy, the equal important expression in this phrase is equally. Now, by no stretch of imagination, if a person is relegated to contest the basic questions such as arbitrability or abuse of process, or the other aspects such as forum non-convenience, before the arbitrator himself or herself, then it is not an equally efficacious remedy. It may be an efficacious remedy, but it is not equally efficacious. In juxtaposition, if he goes to a civil court, this matter can be decided in a much more quicker time, in a much more comprehensive manner. So therefore, I do not believe that Section 41H would come to the rescue of this school of thought in this circumstance, as an alternative to the anti-arbitration injunction. Because of Section 41H, the matter should be heard on the basis of competence theory is not what I subscribe to.
Thank you so much, sir. So there is a related issue that flows from this. Even if a party were to decide to take up its challenge under Section 16, in the circumstance that it prevails and the arbitral tribunal holds that yes, the dispute is not arbitrable or there is no arbitration agreement, the question arises, what is the sanctity of that decision? One view is that that decision is a nullity because the arbitral tribunal itself has decided there is no arbitration agreement, which completely undermines its jurisdiction to even make that decision. So it creates this kind of legal vacuum, and that vacuum can only be fully supplied by a court decree, which is binding and final. Otherwise, the question can be asked as to what sanctity attaches to that decision of that arbitral tribunal. Is it res judicata? If it isn't, is it even something in the eyes of the law? So maybe could I get your view on this? That is this a good reason to say that Section 16 is not an efficacious remedy because the result might be a nullity? Mr. Rao, again, sir, if we could just follow.
Sure. See, again, all of these things only demonstrate that it will take longer for a party to get relief. Longer in terms of time. B, obviously, there is an associated cost. And because it is not in the court framework and it is outside the court framework, chances are it will be much, much more expensive. Going back to the same theme, the use of the expression equally, again, has to be with reference to statutory intent, because ultimately courts are acting in furtherance of what the law has, law as it stands. The Specific Relief Act, was not really intended to deal with injunction suits in the sense of an anti-arbitration suit. But yes, it's an omnibus power. The Arbitration Act comes later. The Arbitration Act does not make a carve out or an exception for the Specific Relief Act. And I'm only going by legislative intent and historical development. More importantly, the principles akin to res judicata, etc., are principles where, I mean, it's, you have to also trust the tribunal. I mean, the only way you will encourage an arbitration bar and therefore arbitration jurisprudence and recognition of your country as a hub where, awards are respected, or at least you get A, quality awards, and B, awards are respected. And the most important, thirdly, is consistency, is to lay the foundations for that. And if we are seen as a country which encourages the ability of trigger happy parties who are unhappy with, a set of agreements that they've signed in the first instance, and there is a dedicated, a shortcut in that sense, because arbitration is seen as a shortcut. And we've seen, how our civil system takes much longer. Of course, much has changed. And I think that's the fight today. It's the Commercial Courts Act versus the Arbitration Act, and the more efficient one eventually will prevail in the long run. And frankly, I see that, in fact, I believe today that the Commercial Courts Act, perhaps if rightly used, probably will get you results faster than an arbitration. And the bigger advantage, of course, is 34 versus an appeal. And that's from a party's perspective, I would want to have a second bite at the cherry with all eyes open and everything possible. And that I can only get in an appeal. I won't get it under a 34. And that's really the risky part of arbitration. So res judicata, why should we not trust the tribunal to look at all of this and deliver a fair award? The legislature was conscious of the fact that yes, tribunals may err, but the legislature did decide that if the tribunal did rule against you, you couldn't challenge it then. You would have to wait till the 34 and then lay that as a foundation. Now, all of that is indicative of only one thing. There is policy which is aimed at encouraging one set of actions. To say, therefore, that a civil court, merely because of these, side alleys, should be able to, exercise jurisdiction. Because again, we're going back to the root of the matter. It's really conferment, A, and B, exercise. I would believe that the object was to take away jurisdiction. Of course, the counterfactual is this. Surely, if it was so clear, all the legislature had to do was to add that one extra line, which you see in every other statute. There is an ouster of no civil court shall entertain any matter. That is perhaps why the gray area might be having this debate. But overall, I would think, even if you were to concede that, yes, this is a situation, then rarest of rare, only in the most oppressive of cases. The difficulty I have with that line is, it changes. It's like equity, it varies with the length of the chancellor's foot. So that's where I stand. I think I'm a very, very pro-arbitration person, despite the fact that I love the civil court.
Thank you, sir. Thank you. Mr. Jain, sir,
I subscribe to the views of Mr. Rao in this context, what he spoke just now. However, I would still like to draw your attention and everybody's attention that please appreciate the legislature, while framing Indian Arbitration Act, perhaps did not intend to make this competence principle as a supreme principle. Had it been so, why would it make as many as 8 or 9 sections, provide for 8 or 9 sections for people to go to the court to seek court's assistance? Even for summoning a witness, a public witness, we have to approach the court through Section 27. So the role of courts was an integral part of the arbitration regime in India. So why this reluctance? Why do we have this feeling that courts are there to impede the arbitration process, or they are in any manner going to take away the autonomy, party autonomy, or the contractual aspect of the arbitration. Courts are there to assist. So it's not for nothing that anybody would come for an anti-arbitration injunction. It will only be in extreme compulsive circumstances that somebody would come and seek an injunction against an arbitration going. And the grounds are also very strong. Tests which have been set up by the courts are very stringent. These being so, where is the difficulty in the civil courts deciding this? So therefore, this aspect needs to be kept in mind, that as many as 8 or 9 sections in part 1 are leading us to courts.
Yes, thank you, sir. Thank you, sir. So the next issue which I'd like to bring the panel's attention to is, this is not coming from a case. This is more of a policy argument that you will hear a lot of arbitration lawyers come up with, where they say that, look, even if the anti-arbitration injunction remedy is necessary in certain circumstances, the only court that should have the jurisdiction to grant it should be the court at the seat of arbitration, because that has supervisory jurisdiction, and that's a principle even Indian law recognizes in terms of supervisory jurisdiction. So how does this argument interplay with the idea behind anti-arbitration injunctions being a mechanism to prevent vexatious and oppressive conduct? I thought we could ask Mr. Jain to weigh in first, because, sir, you've argued this and successfully argued against this proposition in Vodafone. So maybe you could shed some light as to what you feel weighs with the courts on this point.
Ashutosh, in my view, this seat of arbitration theory should not be applicable to anti-arbitration injunctions, because when it comes to the merits of the arbitration, when an arbitration proceeding is going on before an arbitrator, what is being adjudicated is the dispute on merits. Whereas in an anti-arbitration injunction, what is being adjudicated is the ground which has been brought about. So those grounds having been brought about do not have anything to do with the subject matter of the arbitration. So therefore, the court, when dealing with anti-arbitration injunction, is not at all dealing with the merits of the matter. So therefore, linking it to seat is not a correct view. In my view, the anti-arbitration injunction should be available wherever it can be shown that a cause of action has arisen, and especially when somebody is articulating forum non-convenience, how do you want to confine to seat of arbitration? That's the question.
Yes. Thank you, sir. Thank you so much. Mr. Rao, your views on this?
No, I completely agree with sir on this. I think that's the point. Either you don't have jurisdiction, but if you have jurisdiction, then really speaking, you're giving that, you're carving out that exception because it's in the interest of preserving a party's rights and to protect a party from being oppressed or being vexed. Then really speaking, what's the purpose of saying that you go to the seat, wherever the party is or wherever the causes of action is and wherever it's convenient? A court should be able to exercise jurisdiction. Now, whether or not that jurisdiction will be exercised and whether a court will see that as an abuse of process, those are self-contained limitations which a court has to bring to bear in every case. But frankly speaking, once you've decided that a civil court should have jurisdiction, while I see the logic that, you want to, obviously, it's like a three-tiered approach. Firstly, it's competence, and it's only the court at the seat, and supervisory, and then this. I don't believe any real purpose will be served. If you're carving it out, then it should be open up. It should be open-ended, and it should be wherever jurisdiction lies.
Thank you, sir. Thank you for your inputs. So with this, we'll move to a slightly different issue, which concerns the grounds for the grant of anti-arbitration injunctions. Now, there have been two broad approaches that courts have followed. Mr. Jain, in fact, flagged both of those approaches in his initial remarks. One is where there is vexation or oppression, and the other is where the arbitration agreement is null, void, inoperative, or incapable of being performed. Courts have either adopted one or both of these grounds. Now, the first ground, of course, is somewhat vague because there could be n number of circumstances where there is vexation or oppression, whereas the other ground is more precise but a little limited because it only identifies it's closely linked to the grounds under Article 2.3 of the New York Convention and Section 45 of the Act. So if I could just get you to weigh in on which of these grounds makes more sense. If the courts were to continue to grant this remedy, which of these two sets of grounds should they affirm, or should they keep both as they're doing right now? Again, I thought Mr. Rao, could we have your views on this first?
Okay, again, pro-arbitration stance. The idea is obviously to limit intervention as far as possible, and where you want intervention, it should be clear. If I were to adopt that approach, then I would obviously think that vexatious and oppressive is too wide, and really would change with each court and each case. I would err on the side of having null, void, inoperative, or incapable, largely for two reasons. One, of course, drawn from the New York Convention. So even if I were to apply it from an international law standpoint, in a sense, the number of countries that have effectively signed up for the treaty and ratified it, it has virtually attained the status of customary international law. So in a sense, it's binding and it's there for all to see. The other reason is I feel that it is a little more precise. I at least when I looked at it for the first time, I felt while it was precise and interesting, I really didn't see any difference between inoperative or incapable of being performed. Till then, I went and saw WSG, and the Supreme Court has, in a sense, carved out and tried to explain what the distinction is. So, vexatious and oppression again takes us back to the same problem. What is vexatious for one judge? And you run the risk, where suddenly commercial unviability could be treated as vexatiousness. Whereas really speaking, it was meant to target a situation where I am targeting you in 6 different jurisdictions. But again, from an international law standpoint, and more importantly, an international arbitration standpoint, if I am entitled to execute proceedings against you in 6 separate jurisdictions, then there's nothing to be vexed about. You have assets all over the world. I can chase your assets wherever I want. I am, in a sense, dominus litis. So I would think it should err on the side of Article 2.3 rather than keeping it vexatious and oppressive. And again, goes back to the principle. If you're conferring power and you're conferring limited power, it is important to have guidelines. The New York Convention provides that guidance, whereas this leaves it open to the judge.
Thank you, sir. Thank you so much. I'll move from here to a more a slightly different issue, that of consequences of the breach of an anti-arbitration injunction. Now, this is an issue that has only recently been brought and seriously considered by the Indian courts. Now, the Calcutta High Court, in a division bench decision in Devi Resources, has held that a foreign award which was obtained despite the existence of an anti-arbitration injunction can still be enforced as long as that injunction stands subsequently vacated. The question really is this approach appropriate, given that while it is certainly supportive of arbitration, it might effectively dilute the effectiveness of an anti-arbitration injunction and create perverse incentives for parties to breach these injunctions. So if I could just get Mr. Jain to give us his view on this. Does the Calcutta High Court position is something that you would agree with, sir?
No, I do not agree with it. I would say support the arbitration regime by all means. But please, in this process, do not damage the basic jurisprudence which we have developed over centuries. Now, it is a fundamental principle that you can never say that there cannot be a contempt of an honest order. So long as an order has been passed, that order has to be complied with. And to say that merely because at a subsequent stage the injunction was vacated, so we should give effect to the award. According to me, this award is itself is honest. It is a nullity. Yeah. Because any judicial proceedings, any legal proceedings, because for that matter, even when we go in the sphere of legislature or executive, we take it very seriously. So how can we have a separate standard for judiciary or an adjudicatory regime like arbitration? So therefore, in my view, this view taken by Honorable High Court of Calcutta is completely wrong. Even if it supports an arbitration obliquely or in a collateral manner, it is not the just and proper course of action which has been taken. So in my view, as Mr. Rao has just mentioned, that the executability is now almost omnipresent. In any jurisdiction, you can execute an award. So therefore, one needs to be very, very categorical in this, that anything which comes on the table is legally sanitized. We cannot adopt these kind of knee-jerk reactions.
Right. Right. Thank you so much. Mr. Rao, your views on this, sir?
Yeah, sir, I was looking at it from a very interesting point, because I completely concur with you that perhaps, I think the Calcutta High Court looks at it a little simplistically, because it says this is an interim injunction. Ultimately, we'll have to see whether you get a permanent injunction or not. But I thought in practical terms, sir, there's that one issue, because then it again goes back to strategy, and perhaps we'll look to your guidance on this. I get an injunction against a party to an arbitration agreement, and I don't make the tribunal a party. Now the tribunal, the party, therefore, in compliance with the injunction, moves an application before the tribunal and places the judgment of, the Indian court, and says, I have been restrained from proceeding. The tribunal says, I'm the master. The party had the ability to seek an injunction against me, has chosen not to seek an injunction against me. Your point is noted. We are going to go ahead. And you are now liable. I mean, you should participate. If you don't participate, at your own peril. Now, is it open to a party, therefore, in those circumstances to say, I have complied with the injunction. The tribunal has gone ahead and done what it has done. And yes, you're right, sir. If I were to bring that back to the court which granted the injunction, or to the country where the injunction was granted, perhaps public policy may weigh in, and somebody would argue that this award is not enforceable. The flip side is that that small body, of course, of case law, and on the original side, where merely because there is a breach of an injunction and there is sale of a property in violation of the injunction, does it necessarily mean that the sale is void? Can the third party say, I am a bona fide purchaser, I didn't know of the injunction, the sale is valid, etc.? So somewhat similar principles, if one were to bring into bear, would it mean that a court again may decide to treat each case differently, and not in every case where there is a breach of an injunction would the awards be said to be bad? And would that discretion be vested in a court because of the amplitude of public policy in 34, and then of course in 48, and even more the limited applicability of public policy from a 48 perspective, especially when we're looking at an international. I don't think we'll have too many cases where a domestic tribunal would say, I'm going to go ahead. So that is unlikely. But what about a foreign case?
Oh, I agree with you. So far as that aspect is concerned, we have to look into this entire scenario from that perspective as well. But the basic proposition that remains before us is this, that a party violating an injunction is still amenable to other judicial mechanisms through which that party can be reined, or that party can be penalized, or the party who has been victimized because of it can be compensated. But this kind of an exercise cannot be permitted at the level of the tribunals, because if they do it, then of course, I mean, this is something we always would like to stay away from, a situation where tribunals are needed to be made a party, and then we are litigating in a court with tribunals as parties. We have always eschewed that situation. Only those tribunals which are more of a regulator, like SEBI or CCI, these kind of organizations have been litigating in their own name. And also, so far as arbitral tribunal is concerned, in very extreme circumstances, the tribunals are named as party, where tribunals have some role to play. So therefore, I would still believe that Calcutta High Court judgment is not a good thing in the long run.
Thank you, sir. Thank you so much. It was very interesting to hear your views on these two issues. Sir, if I could just ask you very briefly, Mr. Rao mentioned this, and I thought maybe I could get your view on this also. Is it fair to say that such an award would be, even whether or not it is a nullity, would it be considered contrary to public policy or fundamental policy of Indian law, according to you, where it was obtained in breach of an injunction? This wasn't argued before the Calcutta High Court in so much detail, but perhaps it would come up in another case. So, Mr. Jain.
It might be, all right. In my view, yes, it is in violation of public policy, and uh, if such an award is to be challenged in 34, if it is a domestic award, it's to be challenged in 34. There, it can be seen as a ground, and even if it is an international award, there also at the time of assessing its executability, this aspect can be gone into, in my view.
Thank you, sir. Mr. Rao, do you have, would you just want to reiterate your view on this?
Yeah, just on 48, and sir, again on the language, and this is something that at least I think Justice Bhakru in his judgment in Cruz briefly alludes to, that 48 is not carte blanche in terms of that a court will refuse to enforce. It says a court may. So ultimately, it's read in a manner, one could argue that the statute also gives this court the discretion, and that's perhaps what Justice Banerjee seems to have adopted in Devi Resources, which Ashutosh is referring to, that not in every case where there is a breach, perhaps a court may say that I will not enforce the award. But yes, if there is egregious conduct, you're absolutely right, sir, that a court would definitely refuse to entertain. The balance, I guess, is this. The principle of Tayyab Bhai Bagasarwala, where a party who's in breach should not be heard till he or she has purged himself or herself, versus should somebody else suffer because of the fact that a particular party has committed a fraudulent act or committed a violation of a breach of an injunction. So that's I think it's Ashutosh, it's gray, and I would err on the side of yes, if you have to preserve the sanctity of an Indian court process, a court should lean in favor of enforcing its own orders, and the one way to enforce its own orders is to say any order which is in violation of my order I will not enforce. But 48 seems to keep it open, so it again boils down to a case-to-case scenario. But yes, I would err on the fact that breaches of injunction should obviously be taken seriously. And of course, again, the hypothetical that I threw up is something that I think we would rarely see. I don't see any responsible tribunal ignoring a judicial order merely because of the fact that it's passed against a party and not against somebody else. But we have seen instances. Yes, sir. Sorry.
No, please go on. Please go.
No, I was just saying, sir, that very rarely would a tribunal comment on judicial orders received, and unless there is something patently erroneous about that order, I think that the tribunal would follow.
I agree with Mr. Rao to the extent he speaks about Section 48 and its interpretation given by Honorable Justice Bhakru, because obviously if the discretion is taken away, then there is no point in keeping Section 48 in the statute book.
Right.
The basic point which I'm making is this, that I don't want that the standard same as contempt should be applied here.
Absolutely.
But at the same time, it is a matter of propriety. And if it is a matter of propriety, it goes to the root of it. So even if we go on those principles which are applied in the writ jurisdiction, that if a matter goes to the root of the jurisdiction, then even if the appellate regime is in place, the matter can be taken up in the writ jurisdiction. So, applying the same analogy, whenever this kind of a situation arises in a Section 48 scenario, the court will again see whether this is an award which is the offspring of a completely immoral and improper adjudicatory regime. So I am not saying that till now, the way Section 48 has been interpreted, these kind of situations have been dealt with. But in times to come, if such a situation arises, then absolutely, it will be absolutely necessary for the court to look into this aspect.
Thank you so much. This really brings out both aspects to this issue. The last question that we'll consider on the panel today, before we take up a couple of queries that we've received from the participants, is on investment treaty arbitrations. And the question really being that, is there a need for a different approach in case of anti-arbitration injunctions for investment treaty arbitrations, given the fact that the arbitration proceedings arise out of a treaty and the disputes relate to public international law and treaty law? So I thought, Mr. Jain, if you could guide us on this, since you've actually addressed this issue in court on both occasions, both in Khaitan and Vodafone,
yes.
You could tell us how the judges feel about this and what you feel is the right approach to take here.
See, facts of each case will of course differ. But in cases which are governed by BITs, that is bilateral investment treaties, actually this tool of anti-arbitration injunction is absolutely essential to be preserved, because say for instance there is a treaty, and in that treaty is basically primarily meant for what we are articulating in Khetan's case, that the treaty is meant for the bona fide citizens of the other country, that is Mauritius in that case. It is not meant for an Indian citizen who goes in Mauritius and floats a company, only a shell company, does not do any business, and then based on the mere and sheer existence of that company being incorporated in Mauritius, he invokes the treaty. So this can lead to be this can be a situation of abuse of process. This can be a situation where the system, if pressed into service, may be oppressive. So therefore, coming back to your earlier question, which you directed to Mr. Rao, as to which of the two tests should be kept in picture. In my view, for BITs, both the tests should be kept alive, because the situation may arise that that the abuse of process may be so prominent that there could be a requirement for such an injunction. Now, the second aspect, the courts in India have examined these problems from a very, I would say, from international perspective. They have examined the international law in this aspect, and they have come to the conclusion that if an injunction is sought, then it has to be shown very categorically that there is an abuse, as was the case in Vodafone. So therefore, mere allegations have not been taken in a light manner. A deep examination takes place into these kind of allegations. So therefore, as I said, anti-arbitration injunction in itself is an exceptional remedy which is taken in extraordinary circumstances to deal with extraordinary situations. Not every day that somebody will come, whether these injunctions are sought within the regime of Arbitration Act or outside the regime of Arbitration Act. In both these situations, the onus is on the plaintiff to show that what he is alleging has actually happened, and then only he should be in a position to hope or expect for a favorable order. Otherwise, in all probability, he will be relegated back to the arbitrator only.
Thank you, sir. Thank you. Mr. Rao, your views on this point?
Yeah, I must be candid. I don't think I'm very equipped to speak on BITs, but the little that I see, and I've read obviously the decisions of Delhi High Court, I would think that it's important to have a separate regime altogether. That's in the realm of international law. Domestic courts should really refrain from entering into jurisdiction, and that's the only caveat I have. These are international treaties between countries. Even if a party is abusing it, then it's of course open to a country to react and to refuse to honor the BIT. And remedies have to be excised in an appropriate forum. Domestic courts really have no role to play in international disputes. And to give domestic courts the ability to interfere or to act, because then it's seen as an act of state. Really speaking, there is no distinction from an international perspective, whether it's the High Court or it's the government or another arm that acts. So it would be a breach of a treaty obligation, and eventually you'll end up either it's before a competent international tribunal or otherwise. I see the point that Mr. Jain is making, but that of course again is largely because of the manner in which BITs were negotiated. And I think India and a whole bunch of third world entities entered into BITs which were seemingly at that time attractive, but obviously we realized that we got the wrong end of the stick. The correct approach then is to renegotiate. But if you look at it purely as a, in terms of a legal approach, you should have a different regime. And yes, domestic court intervention should be very, very limited.
I have only one point to add, that if you say that the domestic or municipal courts in India should not be permitted to have any kind of intervention in these matters, one must remember that once the awards are passed once any award is passed in a BIT matter, ultimately it will come to the same domestic court for execution. So domestic court is good enough for execution, but domestic court is not good enough for adjudicating this kind of a matter is a question that will have to be gone into.
That's a very interesting point, sir. In fact, I didn't think of it like that. I guess the point I was making was perhaps because in policy, it's important to start negotiating. And I think we've now moved historically. So negotiations on BITs must be obviously done very carefully. But this is a very, very valid point. The question is, does he need to come to your country at all? Can he not attach your embassy elsewhere? And if I was on the other side, I would never come to your country because of the fact that I know I'll run into the same domestic objection. So that's why it becomes tricky. And suddenly we run, Vienna Convention of of the diplomatic immunity aside. Suddenly Indian assets or world over being attached, and that's the problem with these things. But very tricky area. Like I said, I'm not really equipped beyond a point. I mean, I have very, very little knowledge of the BIT framework.
Thank you so much to both our panelists. It's been a very interesting discussion. We have just enough time for a couple of questions. I'll just pick them up from the group chat that we've been having. There's a question from Rishabh Raheja, and I think Mr. Rao, I think this would be something that you might want to answer. Rishabh asks that does granting an anti-arbitration injunction on the ground of abuse of process or vexatious conduct violate Article 2.3 of the New York Convention? Because 2.3 only refers to those specific grounds, null, void, inoperative, or incapable of being performed. So since you had actually flagged this and referred to this as one of the bases on which a court should exercise, would you also agree with this statement that expanding anti-arbitrations would be?
Yes, I would believe so.
Yes. And Mr. Rao, what would be your view on this, sir?
No, I would also agree. I mean, at the end of the day, see, and that's the point. That convention was thoroughly negotiated, carefully thought through. And if parties are expected to, and again, the whole principle of rebus sic stantibus, you are expected to do, you're not supposed to do something that would undermine the basis of the treaty. If you start opening it out in this manner, then then the convention really stands nowhere. So
Right.
Rishabh is absolutely right. It would be, I would argue it's a violation.
Right.
And the practical problem, just one last comment.
Yes,
the practical problem is, where does that take you? Nobody's going to take you to the ICJ for a violation of the New York Convention. But does it mean that you become a less attractive destination? And if that happens, and even when you're inviting foreign investment, and I think there is a consequence. Again, I have this pet judgment which I keep going back to, Justice Sikri's in Shiv Shakti Sugars, where he talks about the interplay of law and economics, and how every court should view its decisions from an economic standpoint, as in the impact on the economy and otherwise. When you interpret international obligations in a manner which is conducive to domestic interest, in the short term you may gain, but in the long term you're effectively driving people away. And if we are looking to be a country which is so-called a world leader, we have to be able to demonstrate that our institutions are robust and are independent and have the ability to discharge and honor international commitments, no matter how onerous they may appear to us, as a country. That's the point.
Thank you, sir. Thank you, Mr. Jain. Thank you, Mr. Rao. I'll just take up one more question, and if we have maybe a couple of minutes, maybe another. But there's a question from Ramya Agarwal, which Mr. Jain, sir, I think this would be something that you would like to answer. She says that vexatious and oppressive are equally important, since many times conditions that lead to a party seeking an anti-arbitration injunction could not fall in the Section 45 grounds, but still that remedy is justified, sir. So would you like to weigh in on this? What, according to you, is the scope of vexatious and oppressive? Is it broad enough to cover all types of vexation that may be caused?
See, I would not believe that in a situation like anti-arbitration injunctions, all kind of the expression vexatious is very wide. It is a sort of very sweeping expression. So vexatious has to be kept within bounds. Vexatious, which will have some kind of an element of abuse, some kind of oppressiveness, and some element of fraud only to that extent, not otherwise.
Right. Mr. Rao, sir, your views on this?
I think I've essentially covered what I had said on this when I was speaking. I agree with Mr. Jain, sir.
Yes.
Absolutely. I think you keep it too wide and then you undermine the entire basis. So it has to be narrow and it has to be limited.
Right, right, sir. So I think we are a little over time. With that, I think I'm going to stop with the questions. I am very, very grateful for your time. And, I'm grateful that we followed this format, which allowed us to explore both sides of the issues. And, there'll be things which people will agree with one way or the other. And I think the best thing we can say is that everyone has found some fuel for their arguments through this discussion, whichever position we take. If that's all right with you, I'd now like to invite Kashish to deliver some closing remarks, and then we can sort of close this session. Kashish.
Thank you, sir. Everyone, thank you, Mr. Jain, thank you, Mr. Rao, and Mr. Kumar for gracing this occasion. It was the first inaugural webinar for the series that we are planning to host for the NLSIR. And more than being a part of the organizing committee, who is generally privileged to have hosted this panel, I'm really glad that I was listening to this panel. I have believed that I understand that the issue of anti-arbitration injunctions is extremely intricate and interesting, but I've always understood it from an academic perspective. But this has actually helped me a lot in understanding the practical considerations surrounding it and how nuanced it is actually in practice. Before I wrap up, I would also like to thank our faculty advisor, Professor Govind Raj Hegde, who was also with us here throughout this panel. He has always been supportive of all of our initiatives and all of our ventures that we take forward in order to improve legal discourse. And soon, based on our discussions held here, we'll be releasing a YouTube video of this discussion, and we'll be launching a competition where a problem related to anti-arbitration injunctions will be posted, and the participations, if they are willing, obviously, can send in their responses, and we'll be happy to publish them as articles over NLSIR Online, the platform that we have recently launched to improve the legal discourse that exists in an open access manner. So our problem will be released, and people can obviously refer to the discussion that we have had via video that will be uploaded on YouTube, and we'll be happy to consider if they are making an original contribution to publish them over NLSIR Online. I'm really grateful to Mr. Jain, Mr. Rao, and Sir for having given us this opportunity to host this extremely interesting webinar today. I hope we can host you some other time as well if time permits. And I understand how busy your schedules are, and thank you for taking the time out today.
Thank you, Kashish. Thank you, sir. Thank you, Mr. Jain. Thank you, Mr. Rao. It was a pleasure to have you, sir. Thank you so
Kashish
much.
And Ashutosh, if you really want to, get the boost of, so sorry. Hello.
Yes, sir. I'm here. Can you hear me?
And I was saying, if you really want to kind of maximize the experience that Mr. Jain brings, you should get him to start talking to you guys about the CPC.
Right.
That is invaluable.
I would love to do that.
So we should get Sir to do one course on that. I'd happily participate just to learn.
Would love to do that any day.
So we've noted you on record now. So we are going to hold you to it. So thank you so much. Please stay safe. Please have a good evening, sir. Thank you so much. Bye-bye.
Thank you so much, Sir Jain, sir. And thank you, Ashutosh. Thank you all.
Thank you.
Thank you, Rajshekhar.
Thank you, sir.